We'll go through the history of youth justice in Canada, starting with the Juvenile Delinquents Act from 1908 to 1984. You don't need to memorize these dates, but you do need to know the order in which the different youth justice acts in Canada came in. So the Juvenile Delinquents Act, then the YOA, or the Young Offenders Act, and then the YCJA, or the Youth Criminal Justice Act. So the motivation for bringing in the JDA was based on the idea that youth were frequently being detained with adults while awaiting trial. And remember, from the child savers movement, this is why we brought in that historical perspective in week 2, the child savers movement wanted to make sure that youth were not being housed in the same facilities as adults, because these child savers believed that adults were the individuals who were responsible for corrupting youth. So there was this growing awareness that there were a number of poor children living on the streets and that they needed to be placed in those reform schools. So to model or to come up with a way to justify placing these individuals in these specific reformatories, we needed an actual legislation guiding the use of these reform schools. And again, this was especially because during the Industrial Revolution in Canada, we were seeing more wayward youth out on the street begging or gambling or engaging in prostitution, engaging in alcohol use. And there was a response to this perceived increase in youth crime. When a Justice System Act is enacted, there's always some sort of overarching philosophy. It's usually fairly coherent. It has one particular goal or multiple goals, all part of the overarching aim. The philosophy of the Juvenile Delinquents Act was really primarily based on the principle of parens patriae, which I think we introduced earlier in the semester. It basically refers to the idea that if the parent is unable to act as the caregiver to the child, then it is the responsibility of the state to assume the caregiving role for that child. So it's the idea that the state is father. The state can take on that paternalistic role. And I'm not saying that's a good thing, but I'm saying that this is the philosophy of the JDA at the time. Under this Juvenile Delinquents Act, there was a very humanistic belief, a very altruistic belief. I think people genuinely did want to see the lives of these youth improve, but I just don't know if they were going about it the right way. So they were targeting individuals who were coming from a poor family background, individuals that lacked maturity and were perceived to lack those middle-class Protestant values. And so the focus of the Juvenile Delinquents Act was to treat the youth and to treat their family, or if they could not treat the family, provide that youth with the surrogate family, whether it's through placement in a reform school or finding an adopted or foster home for that particular youth. The JDA came up with the idea that they were focused on the best interests of the youth. This raises a really important point, and one that lawyers were especially adamant about when they began to target and criticize the JDA. The idea of best interests can be very subjective. Is it the best interests of the youth? Or is it what the adult thinks is in the best interests of the youth? And very often these two things were in conflict. Is the youth wanting to go to a reform school? And if it's not in the youth's own best interest, then it's not really true. In reality, under the JDA, it wasn't so much that people were thinking about what youth wanted. Instead, they were thinking about what they feel was the best scenario for these particular youth. Although treatment was a really big emphasis of the JDA, a major problem was that research had not yet evolved to a point at which we could rely on evidence-based practices to identify what types of treatment would be most appropriate. And this we'll see is a really dark and ugly history of Canada, where there were a lot of experimental treatment programs in correctional facilities. In Ontario in the 1950s and 1960s, they created these really radical experimental treatments that involved, for example, the belief that individuals incarcerated required a caregiving figure, and I'm not making this up, they actually strapped fake breasts to the walls of cells that allowed individuals to receive nutrients from this fake plastic breast. The idea here was to mimic what it would have been like as a child to experience that bond with the mother, so that maternal connection. This also included giving individuals LSD. and then allowing individuals in a particular custody center unit to decide how one another would be punished. And this could involve the use of electric shocks. So there was really heinous intervention strategies with no basis in empirical evidence. And this is why the JDA might have been very unsuccessful in reducing the youth crime rate. It might have been well-intentioned about the idea like we need to provide services and treatment to these youth. But the research base has not yet evolved to a point where this intervention or these intervention strategies could actually be useful. Under the JDA, someone who's defined as a youth in conflict with the law would be a person between the ages of 8 to 16, where the upper bound varied by province. So in some places like BC or Quebec, it could be as old as 18. In a place like Saskatchewan, it could be as young as 15. Under the JDA, a very big component were status offenses to address the perceived immorality of youth. And a status offense is referring to a behavior for which an adult would not actually be punished for. For example, drinking alcohol, skipping school, engaging in incorrigibility, which is basically just not listening to parents. These were all behaviors that could actually bring youth into the formal youth justice system. Under the JDA, what was maybe a very forward-thinking principle was the idea that these were not offenders. These were just youth who were misguided and misdirected. So youth did not actually receive criminal sentences. They received dispositions. And this disposition was kind of like a doctor's report, but for an idea about what the causes of crime are for this young person and how to best intervene. During the JDA, Canada had that distinction between an indictable offense and a summary offense. An indictable offense being an offense for which an individual could receive 2 or more years in custody. All summary-based offenses would be dealt with in youth court, but even a 12-year-old, 14-year-old who had perpetrated an indictable offense could be processed through the adult court system. In addition to these oppressive undertones of the JDA, another major attack on the JDA came from lawyers and judges, because one of the issues was that there was far too much judicial discretion. A judge had so much freedom to give a wide range of different dispositions, and it was often not so much based on the offense that the young person had committed, but the probation officer's report on the background of that young person. So the young person could be blamed not for what the crime was, but for what their history was or what their parents' history was. And this is kind of ironic because sort of like a fundamental principle of Christianity is that the sins of the father are not the sins of the son. That's kind of like a patriarchal reference, but the general idea is that the sins of the young person's family should not be the sins of the young person themselves. And this sort of principle was not adhered to under the JDA. It could result in the young person spending a longer period of time in these reform schools. Another major issue was the idea of status offenses, where the young person is essentially being punished for the behavior that would not be punished if it were engaged in by an adult. So this is sort of tantamount to cruel and unusual punishment. Another issue, which basically exacerbated the issue of judicial discretion, was the idea that across provinces, the maximum age at which somebody would fall under the youth justice system varied. The system in Canada is supposed to be fair for all Canadians, but if different provinces have these different rules, then the system might be perceived to be unjust. Another issue was that these reform schools were poorly funded, they were terrible conditions, and thus not necessarily very conducive to the rehabilitative experience of young persons in custody. Norway would be a great example of what an institution should look like, at least in my opinion. And my opinion isn't based on my politics or my ideology. My opinion is based on what we know about how to prevent crime from happening in the future. We know that specific deterrence is not particularly effective. If somebody is incarcerated, and I definitely do believe in incarceration for protection of the public, but while somebody is incarcerated, why wouldn't we want to help them become better persons, to provide them with the services they need to avoid involvement in criminal behavior in the future? Because even if you don't agree with giving these other persons services, wouldn't you agree with the idea that we should try and prevent people from experiencing victimization. The best way to prevent victimization is to improve the rehabilitative needs of persons in custody. And shouldn't we be focusing on what their needs are so that we can have them released into the community and they won't actually commit further harm and offend against future victims? Another big issue was that despite what the JDA was doing, it didn't seem to actually be having an influence on rehabilitating youth. Indeed, the crime rate in Canada was perceived to be on the rise. Unfortunately, this was tackled by trying to be more punitive when it came to adjudicating young persons. We will see whether it's the YOA, the JDA, the YCJA, a common criticism is that the law is simply not strict enough, that we need to be more punitive towards youth. And often this perspective is not based on what the youth crime rate is actually looking like or what the best response to youth crime actually is. Instead, it's more about ideology.